Good afternoon, Your Honor. Daniel McEer.
All right. Mr. Gu, you are representing yourself. I do have to apprise you that you are before the court on charge of resisting and obstructing a police officer. That is a high court misdemeanor, or what technically is known as a high court misdemeanor and or felony, punishable by up to 2 years, $2,000 fine plus court costs. There are great perils in representing yourself in this. You have to understand that I am going to treat you the same as though you know the laws and the rules of evidence. I will not treat you worse because you are not represented. I will not treat you better or grant any favors or try to clarify anything for you. If, for whatever reason, during any point in this proceeding, you wish to be represented by counsel and cannot afford to hire counsel, counsel will be appointed to represent you. As I have in the past hearings asked you to acknowledge what I've said, I'm going to only indicate that I believe that you understand English. You believe that the words that I have said to you are understood, so that we don't get into, you need to remove the gum from your mouth.
Mr. McEer is back, and this time, he's about to learn exactly why representing yourself in court is a terrible idea. If you're new to the channel, this is part 2 of our earlier video featuring Daniel McEer, a man who seems determined to make every courtroom mistake possible. From the very start, things go downhill fast. McEer refuses to answer Judge Simpson's questions, acting smug and dismissive as if the rules don't apply to him. And just when you think it can't get worse, he's chewing gum in open court, without an attorney by his side. It's a perfect example of what not to do when facing a judge. So buckle up, let's dive in and see how this tense exchange between McEer and Judge Simpson unfolds.
So I will not ask you to acknowledge. I will presume that you do indeed understand everything that I've said. Now, having said that, what are we doing with this case?
I'd like to move for evidentiary hearing or a prelim.
You wish to have a preliminary examination?
Preliminary examination, yes, sir.
Would the people have their witnesses available the second?
We can try, Your Honor, but before moving toward that, would the court be willing to make its inquiries about discovery? I am aware of the defendant having filed a writ of mandamus with the Court of Appeals of the state of Michigan.
Yes.
That was subsequently dismissed without prejudice by the Court of Appeals.
Correct.
Contained within that, though, there are allegations that my office has violated its Brady obligations and has not provided sufficient discovery. So I'm not sure if we're ready to move forward to preliminary exam. The defendant is saying that he doesn't have all of the discovery. That is the concern of the record. I feel compelled to make at this time, though, is that the people have provided, I do believe, complete discovery to the defendant, and I believe that some of the representations that were made in this writ of mandamus that has been dismissed appear to allege that things that have already been denied by this court should be produced. Furthermore, the defendant filed a motion with no notice of hearing attached to it. So there's an outstanding motion in this case as well, no hearing date scheduled. So I'm hoping that you can sort of reconcile both of those things as whether or not discovery is complete, the defendant's prepared to move forward, and if he ever intends to file a notice of hearing to go along with the motion that I received in this case on 11/22.
Mr. Gu, your response?
My response is that I thought this was the hearing that we were setting for the motion. So if I have to set a motion for a notice of hearing for that motion, I will do that today, Your Honor, promptly.
What about discovery?
I'm ready to move forward on my what I meant by my discovery comment was that there's still no exculpatory evidence as far as that I did anything wrong as far as anything that they've submitted. So it was improper for the wording, Your Honor. I apologize, but my ultimate goal is have the prosecution present their evidence against me.
I'm going to indicate discovery is complete because I don't know what you're saying, because what you just said regarding discovery didn't make any sense. As it regards the motion, we will hear the motion the motion will be heard on date of exam.
Thank you, Your Honor.
With it at that point in time. So the people would have their witnesses available on the second.
We could try for the second, Your Honor.
Preliminary examination in person, January 2nd, 2025, 12.
Yeah.
12 noon, that is before me.
Thank you, Your Honor.
And continue.
This guy is the perfect example of why having legal representation is absolutely essential. From the moment he walks into court, his smug attitude says it all. He genuinely believes he can outsmart the judge. I'm not sure what made him think that was a good idea, but if anyone can figure out his mindset, drop your thoughts in the comments, because this is just wild. Honestly, he gives off major sovereign citizen vibes, that same arrogant, self-righteous tone we've seen before on this channel. They all seem to think they're above the law, and it never ends well. Let's be clear, this isn't some harmless misunderstanding. He's facing serious charges for assaulting a police officer, and he's already lost custody of his child because of it. That doesn't just happen by accident, those are severe consequences. Yet, he walks into court like it's a casual errand, chewing gum and dismissing everything like he's untouchable. It's beyond reckless, it's self-destruction in real time. Representing yourself in court is almost never a smart move, and this case proves it. Watching him antagonize Judge Simpson is painful, not just because of his arrogance, but because you can see the judge's patience wearing thinner by the minute. Whether it's stubbornness, delusion, or pure ego, this man is digging his own grave with every word. At this point, it's hard to tell if he's unstable or just dangerously immature. Either way, it's tragic that someone this careless once had custody of a child. But that's going to wrap up this breakdown. I'll be covering his next hearing in January, and trust me, it's one you won't want to miss. If you enjoyed this deep dive, hit that like button and subscribe, it really helps the channel grow. Thanks for watching, and as always, take care.